Hey there, my name is Sal Malhotra, Principal Attorney at Drishti Law. Today, I want to talk to you about the ways a trademark owner can enforce their trademarks effectively and efficiently. It is important to remember that the burden to enforce a trademark's right is on the owner, and each unauthorized use by a competitor devalues your brand. So let's dig into a few strategies that you can implement in your brand management strategy. The basics. Getting a trademark registered is a long journey from application filing to actual registration. And it is imperative that you implement a sound enforcement strategy that includes diligent policing and monitoring. Failure to do so could result in unauthorized use or appropriation of your trademark, which can lead to the cancellation of your trademark and or loss of the rights associated. The idea is to increase the strength of your trademark. Step one is getting registered, but you need a holistic approach that continues to protect your brand from infringement. Let's get to monitoring of trademarks. One of the most overlooked and undervalued parts of a brand management strategy is the emphasis on the monitoring of trademarks. Although registration protects your brand, the lack of proper policing or monitoring will lead to devaluation of your brand by competitors or bad faith actors. A trademark owner can monitor trademarks in multiple ways. You could monitor the USPTO Trademark Gazette. The USPTO provides access to an official gazette published weekly that lists all the applied for marks that have been published for opposition. The USPTO also provides a searchable database of trademark applications and registrations, but this can be a time-consuming and inefficient in the hands of an inexperienced searcher. The second way you can monitor it is to employ a search or monitoring service. A competent trademark attorney will be able to review and analyze your brand's risk exposure and provide ongoing reports of potentially conflicting marks. A simple Google alert is beneficial to any brand, but a quality third-party vendor will provide a comprehensive report. It is often necessary to search and monitor unregistered marks and marks in multiple jurisdictions, including foreign databases. This time-consuming process can be streamlined through an industry-leading search and monitoring service. These services usually monitor the registered and dead trademarks, pending applications in multiple jurisdictions, common law usage, that means state and county records of businesses, and any online presence. It could be websites, social media channels, and much more. Now we get to the enforcement part of your strategy. Enforcement comes in many forms. Number one, I always tell my clients, is patience. It is often unnecessary to go after each and every conflicting usage, but this strategy should be used on a case-by-case basis rather than a blanket approach. The second way to enforce your trademark rights are cease and desist letters. This is a common first step in an enforcement strategy. The letter should focus on informing the infringer about your trademark rights, putting the infringer on notice of this infringement, require the infringer to change or alter the use of the infringing mark, and implied or explicit threat of legal action if the mentioned concerns are not resolved. The tone of your letter depends on the strength of your case. The stronger the case, the more aggressive the tone. It is often best to anticipate the infringer's response while drafting the letter. This is why a measured tone and specific demands are recommended and are key to a good cease and desist letter. The next step in your trademark enforcement journey will be an opposition or cancellation proceeding. The USPTO must refuse a pending trademark application if the applied for mark is the same or confusingly similar to an already registered or previously applied for mark in connection with the same or related goods and or services. Often, an examining attorney will not catch all possible conflicts, and a potentially harmful application to your brand might be published for opposition. In this scenario, a potential opposer has 30 days from the date of publication in the official Gazette to file an opposition. Extensions to file an opposition are often available, and potential opposers can get extensions ranging from 30 days to 180 days only for good causes. The cancellation proceeding. This option is available when an application proceeds to registration. A petition to cancel a mark registered on the principal registration must usually be made within 5 years from the date of the registration. This is usually a proceeding before the Trademark Trial and Appeal Board, but a federal court also has the power to cancel a registered trademark. Federal lawsuits, the trademark infringement lawsuit. When cease and desist letters, TTAB proceedings, and all other enforcement strategies have been exhausted, it is often necessary to engage in federal litigation. The cost and length of this process is dependent on the complexity of the case. Trademark registration is the first step in your brand building journey. It is your duty to protect the rights associated with your trademark. As important it is to be proactive and utilize an efficient monitoring process, once a potentially conflicting mark is identified, you need to execute a coherent enforcement strategy. If you need assistance in protecting your trademark, please feel free to click on the booking link provided below or call my office. As always, this is Sal Malhotra. Thank you for watching.